Hi, I'm Steve Carlson of the Independence Party, and I have taken to the United States Supreme Court in Carlson versus Franken et al. The court might name it after Steve Simon, Secretary of Steve Simon et al. The case regarding the loss of free and fair federal elections in the state of Minnesota. Governor Mark Dayton, together with Al Franken and Mark Ritchie, who has been replaced by Steve Simon, all Democrats, have clearly violated and now have actually repealed laws allowing for Minnesota voters and candidates to demand a valid election with constitutional protections and enforcement during federal elections. The case seeks a reversal of the long train of actions by these Democrats and the Minnesota Supreme Court, who have wrongfully dismissed a petition to the Minnesota Supreme Court to force Governor Mark Dayton to withdraw the election certificate he wrongfully issued to Al Franken on December 19, 2014. Dayton's action was a blatant attempt not only to eliminate one of America's leading vehicles for independent voters, the Minnesota Independence Party, who has given us one of the nation's few third-party governors in recent times, but Dayton and Franken and McCollum further want to destroy the integrity of our federal election process, to take away the voting rights of white males in violation of the 14th and 19th Amendments to the Constitution of the United States. And their quashing of all dissent is a clear effort to protect from congressional review the unconstitutional election practices by the DFL in the state of Minnesota, the major national party who occupies the chief election officer position, the courts, the governor's office, and the attorney general's office. But they occupy those offices as a result of invalid elections with a system of excluding candidates in elections for federal office. They are celebrating the destruction in the 2014 election of the Minnesota Independence Party, which this suit to the U.S. Supreme Court seeks to restore for the 2016 elections, so that the IP can run a candidate for the only statewide office, President of the United States, and continue on as a viable independent third party in Minnesota if we can pull more than 5% of the vote. This is the first year that the independent and third-party voters strongly outnumber the two major national political parties. We have 53% of the American voters identifying with us. They have 47% of the American voters, Democrats and Republicans combined, identifying with them. You can plainly see why it is necessary for them to rely on unconstitutional practices in elections, with the courts sitting on the sidelines just to fend off the independent voters. This is also the year those two corrupt national political establishments, the Democrats and Republicans, are being voted out by two independent candidates, Donald Trump in the Republican Party and Bernie Sanders in the Democrat Party. Clearly these two parties are flailing, and we need free and fair elections to put the voters back in charge. These two parties are trampling on civil rights in each election to dampen the turnout, fill the airways with senseless noise which enrich mass media propaganda companies needlessly, and prevent America from forming an effective government to get the power and resources out of Washington, away from the corruption, and back to Main Street, back to the 50 states. I have submitted to the Court of the United States Supreme Court a copy of the election certificate with Dayton's signature and the time and date, 4:56 p.m., December 19th. The trial in the contest was just begun December 18th, and briefs sought from the parties to be filed December 22nd. So this violation was blatant and was countersigned by DFL Chief of Elections Mark Ritchie, who has been replaced by Steve Simon. Further, I have submitted a copy of the cover letter to Nancy Erickson, Secretary of the United States Senate, lying to her that Franken was duly chosen in accord with the tolling provision in state law requiring that a certificate not be issued while a contest is pending. And he said that those had already been met. When time for appeal had not yet begun, let alone ended, and the three-judge panel established by Chief Justice Lori Gildea had not even addressed the impact on the Independence Party, who fell short of the 5% requirement as a result of desperate duopoly tactics to destroy any viable opposition by the Democrats and Republicans. And the Secretary of the Senate, she Her letter, which I also submitted to the court, requires that if this language is not met, and also true, that the certificate will be returned to the state for re-certification. And so because of the wrongful action of Al Franken, Mark Dayton, and Mark Ritchie, and the refusal of the courts to allow this contest to go forward to the U.S. Senate, this certificate of Franken needs to be pulled. The contest go forward to collect evidence on this and forward it to the Senate along with the Franken re-certification, if that's what comes out of this contest. And to just put a point on it, while this issue was pending at the Minnesota Supreme Court, Dayton had this tolling provision repealed, probably rendering the entire congressional office election contest statute unconstitutional, because only the U.S. Senate can act as a judge in this matter, and the Minnesota judges are usurping the power of the Senate under Article 1, Section 5 of the U.S. Constitution. This scandal in Minnesota is massive democratic corruption, for which TV celebrity Al Franken, I don't know why he's a celebrity, does anybody, is a mere figurehead, a Harvard-educated comedian who seeks to undermine our civilization by attacking marriage while he invites attacks on Christians and Americans abroad and at home. This scandal is a crackdown on democracy and on independent voters and their candidates and parties, as the DFL has circled the wagon for years now, taking strong action to eliminate the Minnesota Independence Party, whose elected nominee for the Senate I am. They are defending and concealing the disenfranchisement of white male voters in federal elections, stacking the deck, rigging the elections, while at the same time they campaign for what they call voting rights. They claim to oppose big money in federal elections, but in reality, they protect a multi-million-dollar voter email address industry in Minnesota alone, blocking communication, free or low-cost, virtually universal communication among independent voters, candidates, and parties, while Ritchie himself used voter email addresses collected by his office to raise funds for his own race and all DFL races and promote his own campaign and DFL campaigns. Now, since Thurgood Marshall, the famed NAACP litigator, took a seat on the U.S. Supreme Court, he began to urge positions that would advance non-white voting blocs. Then came the women's movement, including those who saw the blacks as a threat and sought to buttress the position of white women as voters, workers, etc. Lately, the homosexuals and lesbians, mostly white, have asserted that they too are oppressed in ways which must be protected. Marshall advocated proportional representation by race, according to the Supreme Court in City of Mobile, I believe that's Alabama, versus Bolden, a 1980 case. Well, by 1968, the Democratic National Committee had already changed its rules from prohibiting discrimination to actually encouraging proactive discrimination and the exclusion of white males. A lot of this started in Minnesota. Eugene McCarthy campaigned hard for the nomination, but Hubert Humphrey got it in Chicago. These are both Minnesota national figures. And after this, another Minnesotan, Don Fraser, co-chaired the McGovern-Fraser Commission, which nominated McGovern in 1972 and instituted proportional representation, exactly what Marshall had sought and that the U.S. court had said is inconsistent with the U.S. Constitution, with the 14th Amendment. And right now, Minnesota requires you to agree that you will back gender quotas, race quotas, and quotas for homosexual or lesbian delegates in order to even vote or participate in a precinct caucus or convention. And these quota-ridden conventions endorse federal candidates to get directly onto the general election ballot. And only the very rich, like Mark Dayton, can take on an endorsed candidate. And now this party has joined with the Republicans to knock the IP party off the ballot. I'm asking the Supreme Court to put the party back on the major political party status and to let this contest go to the United States Senate so that the Senate will guarantee Minnesota a Republican form of government, as they are required to do by the U.S. Constitution's Guarantee Clause, as well as the First Amendment, amendments protecting voting rights, and for the prescription in advance of elections, of election laws, and the enforcement of those laws during an election period. This is required by Article 1, Section 4 of the United States Constitution. And so the courts in Minnesota have to do their job. But their job is just to collect evidence and forward it to the Senate. They have usurped the power of the Senate. Now I'm asking the court to make sure the court, the U.S. Senate, and the U.S. House are not barred by this anti-democratic Minnesota Supreme Court from fulfilling their constitutional duty to guarantee the state of Minnesota a Republican form of government where the Constitution is followed. The Constitution gives to the state legislature the broad grant of authority to determine in advance of each federal election, and then only the U.S. Senate itself may sit as judges to make sure these laws are constitutional and that they are enforced. Now I'm going to be putting up videos through this U.S. Supreme Court petition, but let me close now by saying that even the DNC, Democratic National Committee rules for 2016 guard against quotas and against oaths to agree with quotas. And I have presented this to the U.S. Supreme Court. This is from the 2016 DNC rules for state delegations. A. State parties shall adopt delegate selection plans, affirmative action plan, and inclusion program which contain explicit rules and procedures governing all aspects of the delegate selection process. These rules shall include, but are not limited to, and then it goes to Rule 5, non-discrimination. In order that the Democratic Party at all levels be an open party which includes rather than excludes people from participation, a program of effective affirmative action and inclusion is hereby adopted. Discrimination on the basis of status in the conduct of Democratic Party affairs is prohibited. In order to continue the Democratic Party's ongoing efforts to include groups historically underrepresented in the Democratic Party's affairs by virtue of race, ethnicity, age, sexual orientation, gender identity, or disability, each state party shall develop and submit party outreach programs, including recruitment, education, and training, in order to achieve full participation by such groups and diversity in the delegate selection process and at all levels of party affairs. And in Rule 6, the promises of democratically elected government and the right to vote have not always been extended equally to all Minnesotans. Historically, certain groups of Americans have been explicitly denied the right to vote or have been subjected to discriminatory and exclusionary practices like these with the intended effect of denying them voting rights. In recognition of this past history of discriminatory denial of the franchise and in order to encourage full participation by all Democrats in the delegate selection process and in all party affairs, the national and state Democratic parties shall adopt and implement affirmative action programs with specific goals and timetables for African Americans, Hispanics, Native Americans, Asian Americans, and Pacific Islanders and women. That little word at the end, 50% of the population or more. They're a minority too. The goal of such affirmative action shall be to achieve participation in the delegate selection process and in party organizations at all levels of the aforementioned groups, as indicated by their presence in the Democratic electorate. Now what that means is proportional representation. Whatever their proportion according to the national rules in the Democratic electorate, but in the state of Minnesota, it's the whole state. This is going to be the quota which they're going to have to meet. Now, however, they go on to say this goal shall not be accomplished either directly or indirectly by the party's imposition of mandatory quotas at any level of the delegate selection process or in other party affairs. Now, as is already the practice in some states, like Minnesota, state parties should use goals to achieve these ends. However, in no event may such participation be accomplished by the use of quotas. Now let's go to Texas, where they say in their state plan, no test of membership in nor oaths of loyalty to the Texas Democratic Party shall be required or used if it has the effect of requiring prospective or current members of the Democratic Party to acquiesce in, condone, or support discrimination on the grounds of race, sex, sexual orientation, gender identity, age, color, creed, national origin, religion, ethnic identity, economic status, or disability. The lists get longer and longer. Further, discrimination on the grounds of race, sex, sexual origin, gender identity, age, color, creed, national origin, religion, ethnicity, ethnic identity, economic status, or disability in the conduct of the Democratic Party affairs is prohibited. The Democratic Party at all levels shall support the broadest voter registration and participation without discrimination on the grounds of race, sex, sexual orientation, gender identity, etc. It shall be the duty of the state chair and party officers at all levels to take affirmative steps to encourage young people, women, and minorities to seek selection of delegates to party conventions and as members of party committees, so they shall be represented in reasonable relation to their presence in the state. Again, quotas. Now take a look at Minnesota. Now this is state law. This is not a private organization like the DNC claims to be, or as the DFL pretends it is, even though they claim in their DFL Constitution they will never violate the Constitution of the United States. This is Minnesota Statutes 202A.16, participation, agreement with party principles, in which they say, only those persons who are in agreement with the principles of the party as stated in the party's constitution, that's the DFL Constitution I'm reading to you from, and who either voted or affiliated with the party at the last state general election or intend to in the next, may vote at the precinct caucus. So you can't vote, you can't participate unless you agree with all these quotas. And then they go on to say, we encourage all Democrats to select affirmatively such individuals when voting. So you have to vote for these people now, according to these bylaws, so that such groups shall be represented on such delegations and committees and in party offices in reasonable proportion to their presence in the state. So again, you have to vote for them to be in that slot. Now, if you don't get that, these affirmative steps shall provide a basis for review and challenge of the delegation as specified in the bylaws and printed in the call to convention. So you hear this all the time in the caucuses and conventions of the Democrats. Now, in other words, in Minnesota, we have a DFL state party that has quotas. Quotas for women, minority, sexual type groups that the party leaders are drilled to match to the presence in the state of these groups. Now, these are directly and indirectly quotas in violation of even the DNC rules. Further, if you want to vote in the DFL party, to vote for a candidate, such as myself, for endorsement, you cannot participate. You cannot vote unless you first agree to these quotas. This is an oath, like Texas bans. Why do you think you see a lock by the first woman Democrat in the Congressional District 4, Betty McCollum? Why did Amy Klobuchar get in for U.S. Senate in a cakewalk? Why will Hillary try to lock up the nomination in Minnesota with delegates? Because of a gender quota. No matter how noble the goals of the DFL might seem to them, this is not supported by the Constitution. And the DFL in Minnesota is not even pretending that there is some historical record of discrimination against women in Minnesota that justifies this lockout of white males. Now, let me read to you what the DNC says that shows they know they're on thin ice. This goal shall not be accomplished either indirectly by the party's imposition of mandatory quotas at any level of the delegate selection process or in other party affairs. But they go on to say that if they force equal division between men and women as endorsees and all the other party officers, this in advance is excused from being a gender quota. So they say, we know this looks like we're violating it by demanding at least a majority of women, but in fact we're not because we say so. So they seek to excuse in advance their knowing use of gender quotas throughout the nation. Is it any wonder that Hillary Clinton feels so confident while she's playing with classified information on her home computer? Because gender quotas will unconstitutionally boost her. I'm saying to the United States Supreme Court in this position that they are not bound by this Democrat self-excusal of their quota practices. Now, I deal with a number of issues, not just the quotas, but this is what really kicked it off in 2012, and we've got to get this straightened out. Now, I'll post recording of segments here from my Supreme Court petition on YouTube or at my website, stevecarlsonforcongress2010.com. Thank you for watching.